Hi there. This is a question I got today from a client who emailed me for confidentiality. I won't disclose private information, but I'll read you what she wrote. I'm in Canada on a visit visa. I was invited by my mother, who has a citizenship from about 20 years. She did not include me in her initial document when she applied for PR for reasons as she would not have qualified herself. Now I'm in Canada. I applied for work permit. I was denied twice. My only option now is to apply for PR under H&C. I need legal advice. So let's kind of, dissect this. And a couple of things that she's mentioning that's important. Essentially, her mother did not inform immigration or IRCC that she has a daughter. And as you know, in order for the daughter to qualify under the family class, she must be disclosed. And if you don't disclose, then you can never, ever sponsor this child, even if you can show that this is biologically your child. So according to immigration, she doesn't have this child. Again, even if you show birth certificates, DNA tests, it doesn't matter. You don't have this child. So this is very important because a lot of times clients don't complete the family information form or declare the dependent because they were ill-informed, and then they say, I'll do it later. I'll sponsor them at a later time. And that, unfortunately, can never, ever happen. Many will tell you, okay, submit an H&C argument or try to appeal it. I personally have never seen such applications come approved because the law is clear. You don't declare your dependent, therefore you don't have dependent. So in this case, she's basically saying she's applied for work permit. So my first question to her would be, in the work permit application, you too had to disclose family information. Did you disclose your mother? So that's the first thing that I kind of have to flesh out with the client to see what she stated and what she didn't state. Second, what's important is that she's basically saying, I don't have any other options because her work permit they've been refused, and she's considering H&C. So assuming that these facts are correct and she's done her research and she truly doesn't qualify for anything else but humanitarian and compassionate application, she has to consider a few things. To qualify for H&C, she must physically be in Canada. So let's assume she's physically in Canada. She does not need to have legal status. So the fact that her work permit is denied, she may be illegal in the country, and technically that's okay for H&C. Of course, if you can maintain your status, if she could have done a change of status to a visitor, highly recommended, but it's not the end of the world. It does not make her ineligible to submit a H&C application. But when she does submit the H&C application, she has to, again, declare her family. Why this is important is because her mother indulged in misrepresentation. We want to make sure that she doesn't. So just because mom made that mistake does not mean she should. Because if immigration finds out that she doesn't declare her mother, I mean, we all have a mother, they can refuse her application and ban her from Canada. So in her case, she must declare her mother, her biological mother. And it doesn't affect her H&C. Why? Because for H&C, her application, the merits to get that approval have nothing to do with her mother's application. It has nothing to do whether you have a biological mother or a mother that you know. That's not the criteria. The criteria for an H&C application to get approved is exactly that. Do you have humanitarian and compassionate reasons to essentially get an exemption from all other categories to apply for PR? What are your H&C grounds? So I don't know what her ties are to Canada. I don't know how long she's been in this country, what establishments she's done here in this country. Those are the factors that the officers will focus on. Now, of course, prior to recommending H&C for this client, I will assess and ensure that truly there's no other option for her. And if H&C is the final application for her, I will also inform her that, of course, mention your biological mother in the application. And you can also argue that the reason you didn't have alternative options, such as child sponsorship, is because your mother failed to mention you in her application. Last component I'm going to mention here, can that have a domino effect on her mother where IRCC can go back to her and say, you've misrepresented? Absolutely. Will they? Probably not. It depends on the officer and how far they want to take it. But if the mother is a Canadian citizen and she failed to disclose a dependent child, I don't think immigration is going to go after her. Can they? Sure. Probably not. If you have any questions about H&C applications or anything related to not disclosing something in an application, feel free to give us a call today. Thank you, and until next time.